and welcome everyone. Thanks so much for joining us for today's Lunch and Learn, Unpacking the 2020-2021 United States Supreme Court Term. We have teamed up with our friends at ACLU Maine, Equality Maine, Maine Women's Lobby, League of Women Voters of Maine, Maine Education Association, and the Maine Association of Criminal Defense Lawyers to welcome James Romoser today. James is a legal journalist, a former First Amendment litigator, and the editor of SCOTUSblog, which provides independent news and analysis about the Supreme Court. We are delighted to have him with us today to discuss the major cases that the Supreme Court has decided this term and to preview what's ahead. My name is Kathleen Neal. I am the Director of Policy and Partnerships at Maine Conservation Voters and Maine Conservation Alliance. Our organizations represent more than 8,500 members dedicated to protecting Maine's environment and our democracy. MCA does that through education, collaboration, and advocacy, and MCV by influencing public policy, holding politicians accountable, and winning elections. A few technical notes for today's event. We will hear from James and then tackle questions at the end. You don't have to wait though. You can send your questions to me through the chat whenever they occur to you, and I'll keep track of them and ask them of James when the presentation is finished. You can message Will Sedlak for help with any technical difficulties. This event is being recorded and the video will be posted on our website later this afternoon, where you can also find recordings of all of our previous Lunch and Learns. Thank you again for joining us. And James, I will turn it over to you.
Thanks so much. Really happy to be here. I'm really excited to talk to you all about what the Supreme Court has been doing this term, what it's likely to do in the coming weeks, and what it might do next term, and talk about both the court's impact on environmental issues, because I know that's what a lot of you care a lot about, but also some other public policy issues as well. So if you can go to the first slide, Will. I'll break today's presentation into 3 parts. First, I'll talk about some of the biggest cases the court heard this term, which are still awaiting a decision. And those decisions should come down in the next few weeks, sometime in June. I'll talk about a few cases with specific implications on the environment that were heard this term as well. And then we'll look ahead a little bit to the 2021-22 term starting in October, which is already shaping up to be a pretty momentous term for the Supreme Court. And I'll try to leave plenty of time for all your questions as well. Before I get into the substance, and you can go to the next slide, Will, I just wanted to set the stage a little bit and talk about what the Supreme Court looks like right now. You're looking at a picture of the court as it existed a year ago when Ruth Bader Ginsburg was still a member of the court. But the past 12 months have been a major transition ideologically. Back 1 year ago, the court was closely divided 5-4 with 5 conservatives and 4 liberals. Chief Justice John Roberts occupied the ideological center of the court. And while the court was very much conservative, last June, the court did hand down a number of major decisions that either took very narrow and minimalist positions in some of the most hot button issues, or even reached outright liberal results. Those cases included an abortion case, a case on presidential immunity, the DACA immigration program, and anti-discrimination protections for LGBTQ people. And the outcomes of those rulings and the fact that they did not lean very conservative has been largely attributed to John Roberts and the fact that he has taken a more incrementalist, a more moderating approach, and has not gone as far as the members of the court's right flank. That all changed last September when Ruth Bader Ginsburg died. As you all know, shortly after her death, the Republican Senate quickly confirmed Trump's nominee to succeed her, Amy Coney Barrett, just weeks before the election. The court is now divided 6-3 with conservatives in the majority, and Roberts is no longer the swing justice. It's now possible for the conservative wing of the court to move the law more aggressively in a conservative direction because they no longer need Roberts's vote. So far this term, we haven't seen much of that, to be fair. Many of the court's rulings that it's handed down since Barrett joined the court last fall have been narrow technical rulings on somewhat arcane issues. Many of the rulings have been unanimous. But as I'm about to talk about, there are a few blockbuster decisions we're awaiting in June, which are more likely to be ideologically polarized. And there are already signs, as I mentioned before, that even if this current term is on the slower side, next term could really end up being one of the most consequential terms in the court's history, as the court has already agreed to hear extremely divisive cases on abortion and gun rights, and very well might also weigh in on the legality of college affirmative action as well. Next slide, Will. So the first case I'll talk about is the one that most people are probably a little bit familiar with, which is about Obamacare. It's a direct constitutional challenge to the Affordable Care Act. And as many of you likely know, this is not the first time that this law has been challenged at the Supreme Court. In order to understand what's going on in this case, I need to give a little bit of background on the prior case. So if we go back to 2012, opponents brought the first constitutional challenge to Obamacare. And that lawsuit alleged that a certain provision of the law called the individual mandate or the insurance mandate was unconstitutional. As many of you know, probably Obamacare in its original form required virtually all Americans to purchase health insurance. This is the mandate provision. And opponents alleged back in 2012 that the mandate was unconstitutional. And back then there were two primary arguments for why the mandate might be constitutional. The first argument was that it's a valid exercise under the Commerce Clause, which gives Congress the power to regulate interstate commerce. And the second argument was that it's valid under Congress's taxing power, the power of Congress to issue taxes. And so when that case came down, a majority of the court ruled that the individual mandate was unconstitutional under the Commerce Clause. They said, yes, Congress might have the power to regulate interstate commerce, but it does not have the power to coerce or command or force Americans to buy a commercial product. But critically and famously in that case, Roberts switched votes and sided with the liberals and upheld the individual insurance mandate under the alternative justification that it was a valid exercise as a tax. How was the mandate a tax? Basically, the reason was that if people do not comply with the insurance mandate, if they declined to buy insurance, they would have to pay a tax penalty. And so Roberts said, this is just a regular tax like anything else, and so it's constitutional, and the Affordable Care Act lived on. Now, fast forward to 2017. What happened in 2017 was that Congress eliminated the tax penalty that was attached to the individual mandate. They essentially zeroed it out. And the way that Congress did that was not to simply delete the individual mandate from the statute. As a technical matter, the mandate is still on the books. There is still a provision in the ACA that says essentially, thou shalt purchase health insurance, okay? But what Congress did was it simply reduced the penalty for noncompliance to $0. So as a practical matter, there actually really is no requirement anymore under the ACA to buy health insurance. Even though the language is still existing on the books, you are not penalized in any way if you don't buy health insurance after 2017 and that act of Congress. Now, as a side note, very interestingly and surprisingly, the law has continued to work just fine without the individual mandate. It turns out that people don't actually need a mandate to want to have health insurance, okay? But what this did, and the way that Congress did this, it set up this latest challenge. And basically what the opponents, which is essentially a group of red states backed by the Trump administration, what they said was that the individual mandate is no longer constitutional because there's no longer a tax connected to it. And we already know from 2012 that it's unconstitutional as an exercise of the commerce power under the Commerce Clause. Now that there's no tax penalty, it can't be justified as a tax either. And so therefore the mandate is now unconstitutional. It's been rendered unconstitutional by what Congress did. And furthermore, the opponents argue, the mandate was so inextricably tied up with the rest of the law, all of the other provisions, that not just the mandate must be struck down, but the entirety of the law must be struck down. That is the argument. It is a highly ambitious argument. And I think it's very fair to say that the vast majority of serious legal scholars on both sides of the spectrum do not believe that this argument has merit. However, lower courts, lower conservative courts did side with the opponents, and that's how this case came up to the Supreme Court. It was argued back in November. At oral argument, several of the conservative justices, notably Brett Kavanaugh, expressed great skepticism about the idea that the entire law must be struck down, even if the mandate is unconstitutional. And so things were not looking good for the opponents after the oral argument. And I still think it's pretty unlikely that the Supreme Court is going to issue an opinion wiping away the entirety of Obamacare. On the other hand, it has been quite a few months since the argument was held. If this was a very straightforward decision, you might have expected the decision earlier than this. We still haven't received a decision. It should come any day now, any week now. And so it'll be interesting to see what happens. Now, I should note that there is a threshold procedural issue about whether the opponents, the red states, have what's called legal standing to even bring this lawsuit in the first place. And that is one way that the court could simply avoid deciding the merits of the case. If they decide that the opponents don't even have standing in the first place, then they don't need to even decide the substantive constitutional issues. In addition, if they find that there is standing, the court could decide that the mandate itself is unconstitutional because it's no longer backed by a tax. However, they could leave the rest of the law standing. And the practical effect of that would be nothing. Everything would remain the same. Because as I said, the mandate is simply on paper right now. It exists only on paper. It doesn't exist as a practical matter. And so striking down the mandate itself as unconstitutional has no effect on the operation of anything else in the Affordable Care Act. Medicaid expansion, protections for pre-existing conditions, and many, many other provisions of the ACA that have become enshrined in the country's healthcare system would remain standing. But if the court went that further step and answered question number 3 on the slide here in the affirmative, then all of those provisions could theoretically be wiped away by a ruling from the Supreme Court. And so we'll see what happens. Next slide, please. The next case I'm going to talk about is about voting rights. And this case comes from Arizona. And Arizona, like many states, has restrictions on certain voting practices. And there are 2 policies at issue in this case. The first is a ban on what's called ballot harvesting. And that's kind of a loaded term, but it's basically the process of one person gathering up a few or a dozen or several dozen early ballots from a variety of different people, and then returning them to the election office, submitting them in bulk. Arizona bans that practice with a few very limited exceptions. The second policy is what's called the out of precinct policy. And under that policy, basically, if a voter casts a ballot in the wrong precinct, the entire ballot will be scrapped. And so to give you an example of how that would work, let's say I recently moved and I don't know what my new voting location is supposed to be. So I mistakenly go to the wrong precinct, my old precinct, and cast a ballot. And let's say I vote in 3 different races: the presidential race, a race for US Senate, and a town council race. And of course, I was eligible, no matter where I lived in the state, to vote for president and to vote for Senate. But let's say that because I voted in the wrong precinct, I ended up casting a ballot in the wrong precinct race, in the wrong town council race. I was supposed to vote in a different district in the same town council. Now, some states would allow my votes for president and Senate to stand because I was allowed to vote in those races. And the states would only throw out the town council race that I mistakenly voted in. Arizona, though, and other states will throw out my entire ballot if I vote in the wrong precinct. And the Democratic Party challenged both of these policies, saying that they have a disproportionate impact on minority voters. And I could talk a little bit more later about why the impact might be disproportionate for minority voters. But suffice it to say that, I could talk later if you have questions about that. But suffice it to say that Democrats challenged these policies under Section 2 of the Federal Voting Rights Act, which bars racial discrimination in voting. And they said that these policies are racially discriminatory. This case was argued back in March, and I think it's fair to say that the Roberts Court has not interpreted voting rights robustly. Roberts, in one of his most important decisions, has already dismantled a separate provision of the Voting Rights Act. So it's very hard to see the court siding with the Democratic challengers here. But the question that I'll be watching is how exactly the court upholds the two policies at issue, assuming that the court will uphold those policies. Because when the court does so, it's likely to clarify the test for evaluating restrictive voting measures throughout the nation. And that test is going to affect other future challenges to other restrictive state voting laws, including a lot of laws that we've seen pass in other states that are actually far more restrictive than the Arizona policies at issue here. And so depending on how the Supreme Court articulates that test, that is going to determine how future courts, how much scrutiny future courts will evaluate other state voting restrictions. Next slide, please. And finally, the third sort of blockbuster case that I'll just briefly touch on is Fulton v. Philadelphia. And this is a clash between religious rights and the rights of LGBTQ people. The background is that Philadelphia has a child welfare system in which it works with private organizations to place foster children with families. And the city also separately has a broad non-discrimination policy that prohibits discrimination on the basis of sexual orientation. And Philadelphia learned that one of the foster care organizations it worked with, a Catholic organization, refuses to place foster children with same-sex couples. Or incidentally, they also refuse to place foster children with unmarried couples as well. And so because, according to Philadelphia, the organization was violating the non-discrimination policy, the city decided to stop working with the Catholic group. The city said, you, Catholic organization, you are not allowed to participate in our foster care program anymore. And so the Catholic group sued, saying that this was a violation of their rights to exercise the religion under the First Amendment. They said this exclusion is basically a punishment or a penalty for their sincere religious beliefs. And the case is really important because it's going to clarify the extent to which religious groups are entitled to exemptions from laws that allegedly discriminate against them, specifically general laws that apply to everyone, but allegedly discriminate against religious groups because of their beliefs. This case was argued back in November. Again, it's been quite a while since the argument. We're expecting a decision, like I said, in June. And it's just worth noting that this is an area on which the replacement of Ruth Bader Ginsburg with Amy Coney Barrett could make a big difference. There have been a series of emergency rulings this year due to the pandemic, in which the court, since Barrett joined, has sided with religious groups who have claimed exemptions, who have sought exemptions from state COVID-related restrictions on large gatherings. And the court has generally sided with those groups since Barrett joined the court. Most of those rulings have come in short, unexplained orders on what's called the shadow docket. But this opinion in Fulton will be a full-fledged opinion. And so it's going to be a chance for the conservative bloc to really lay out what it's thinking about the state of the law on religious liberty. Next slide, please. I want to make sure we have time for questions, so I'll try to wrap up pretty quickly. But before I do, I wanted to talk about 3 other cases, which are a little less high profile, but I think will be interesting to you all because they have environmental implications. And so the first one is called BP v. Baltimore. This is a case that raises at its base a fundamental issue about climate change, but as it came to the Supreme Court, it's honestly quite a narrow and dry procedural issue. The background is that the city of Baltimore sued a number of fossil fuel companies to try to hold them liable for costs associated with climate change. And this is one of several other similar lawsuits around the country right now. I think it's fair to say that these are somewhat cutting edge and innovative lawsuits, and I think it'll be interesting to see where they go in the coming years. And I think eventually the Supreme Court will be asked to weigh in on the substance of these sorts of claims to hold companies responsible for their role in climate change. But for now, this is just purely has been a procedural issue. The issue boils down to whether these cases should be heard in state court or federal court. And in these kinds of cases, generally, plaintiffs like the city of Baltimore want the case to be in state court. They feel that the rules there are more favorable. They feel like the judges are going to be a little more favorable to the local plaintiffs. And defendants, on the other hand, like the fossil fuel companies here, prefer to be in federal court. They think that the procedural rules are more protective of defendants, and particularly with how the federal judiciary has become much more conservative after Trump's many appointments to the bench. I think defendants feel that they're in better territory in federal court. So in this case, Baltimore, of course, sued in state court, in Maryland state court, local court for them. And there's a procedure for defendants to try to take the case and move it into federal court. And that's what BP and the other companies tried to do here. When they got into federal court, the first thing that happened is that the federal judge said, no, I'm not going to accept this case. This case belongs in state court, not in federal court. So the federal judge threw the case back, issued an order throwing the case back to state court. And now the question is, can the companies appeal that order? That's the procedural issue. And I won't bore you with like the nitty-gritty details, but you can go to the next slide, Will. But just last week, actually you can go back one. I have the holding on the slide. Just last week, in an opinion by Neil Gorsuch, the court ruled 7-1 that the companies did have the ability to appeal that order. The court, to be clear, did not say definitively that the case belongs in federal court. They just said that BP and the other companies could continue making arguments that the case should be in federal court. So literally, there's like the fight over the jurisdiction of like whether state or federal should have jurisdiction over this case is just going to continue is just going to continue as a result of the court's ruling. So what are the implications here? It is a narrow procedural ruling, but I do think that this ruling makes it slightly more likely that companies will be able to have these kinds of cases heard in federal court because they have another chance to make an argument that they belong in federal court. And perhaps more importantly, it also gives these companies like additional procedural rights that they can use to prolong the litigation, which is really what is going on here. They want to drag this out. as long as possible. And the ruling last week allows them to do that. Next slide. A second case with environmental implications comes to us from the island of Guam. And this is about a large hazardous waste site on the island known as the Ordot Dump. Next slide. And there's a picture of the Ordot Dump. And if you go to the next slide, you can see, it looks a little better there, but that's also a picture. So basically, starting during World War II, the US Navy used what was once a valley on the island of Guam and used it to dispose of various toxic waste, including Agent Orange, other toxic chemicals, discarded munitions. Eventually, the valley, the picturesque valley, became a 270-foot mountain of hazardous waste, which you can sort of see there from the picture. So it still exists today. Guam is supposed to be cleaning up the site. In 2017, it estimated the cleanup costs would total $160 million. And so the territory sued the US government under the federal Superfund law for help with the cleanup costs. Guam said that, hey, it's the Navy that put all this waste here in the first place, so the federal government should at least help us with costs of cleaning up the site. The federal government argued that because of a technical statute of limitations issue, Guam could no longer sue under this theory. But just on Monday, next slide, please. Just on Monday, the court unanimously sided with Guam, issuing a decision that said that the territory can proceed with its lawsuit against the federal government. Next slide. And finally, I want to talk about an interesting pipeline case. This is called Penn East Pipeline versus New Jersey. And it's a case about a proposed pipeline that would run through parts of Pennsylvania and New Jersey and bring natural gas from basically the Scranton area to the eastern seaboard. And if you go to the next slide, I think I have a map of what the pipeline route will be. So yeah, you can sort of see it here. So this proposed pipeline is very controversial in New Jersey, which by the way is my home state, go Jersey. And so New Jersey is trying to stop the project, but Penn East, the pipeline company, is attempting to move forward with it. And the issue here is that a lot of the land along the pipeline route is owned or controlled by the state of New Jersey. So what Penn East did was it sued New Jersey, seeking to seize that land, seize that property, using the power of eminent domain. Now that sounds a little strange. I mean, why would a private company be able to use eminent domain to seize property? Usually only the government can seize property through eminent domain. And in particular here, it's like almost reversed. A private party is trying to seize land from the government itself. Remember, this is land owned by New Jersey. Well, the reason that it may be able to do that is because a federal law called the Natural Gas Act essentially delegates the federal government's power of eminent domain to private companies that are building pipelines. So Penn East does have the power to acquire property along a pipeline route using eminent domain. The question is whether it can acquire property owned by a state. And New Jersey has argued before the Supreme Court that it should be immune from these eminent domain lawsuits under a principle known as sovereign immunity. And that's essentially a constitutional principle that basically just says in general, you can't bring a lawsuit against a state. So that decision hasn't come down yet. The argument was just last month. But this case has a lot of implications for future pipeline projects. The industry has told the court that if the court sides with New Jersey here, it will essentially give all states a veto power over pipelines within its borders. And according to the industry, that goes against the whole concept of the Natural Gas Act, which was basically trying to federalize the process of developing pipelines. And even if a single state doesn't want a pipeline, for NIMBY reasons, there should still be a procedure for these pipelines to go forward once they've received federal permits. Next slide, please. And so finally, before I just move to the Q&A, I'll just preview 3 other cases for next term. All the cases I've discussed so far have already been argued this term. The current term ends at the end of June. And like I said, the next term is really shaping up to be quite momentous. One of the cases the court has already agreed to hear this coming fall is a major Second Amendment case. This is a constitutional challenge to a New York gun control law, which is similar to many other states' gun control laws. And essentially what New York says is, if you want a license to carry a gun outside your home, you need to show a special need or a proper cause. There are these various sort of legal terms of art that are used in this context. But essentially, New York says you need to show like a good and specific reason for why you need why you should have the right to carry a gun outside the home. So for example, something like if you have like a specific stalker or something and you've issued a restraining order against a person, then that might qualify as a special need. You might have a special need for protection according to the state of New York. But one of the plaintiffs here says that he lives in a high crime neighborhood and he would like to carry a gun for self-protection for that reason. And his application was denied. And New York said that's not good enough. And so in prior cases over the last decade or so, the Supreme Court has interpreted the Second Amendment to provide an individual right to own and possess guns inside the home. And this is the next big Second Amendment case because this applies outside the home. And the court will probably clarify to what extent the Second Amendment protects the right to carry guns outside the home. It's going to implicate many, many state and local gun control measures. And it's going to clarify a very unsettled constitutional question. Next slide, please. You thought guns wasn't divisive enough, then we moved to abortion. This is another case that the court just recently agreed to hear this coming fall, and it's definitely a big one. This is a constitutional challenge to a Mississippi law that bans virtually all abortions after 15 weeks of pregnancy. And it's essentially a direct challenge to the court's abortion precedents, namely Roe v. Wade and a 1992 case called Planned Parenthood v. Casey. And in those prior cases, and in others as well, the Supreme Court has said that states are allowed to restrict pre-viability abortions, but they cannot totally ban them. And in Casey, and I think, in Casey, based on the medical evidence there, the court said that the line for viability was at about 23 or 24 weeks of pregnancy. And here in this case, what Mississippi went and did is essentially banned all abortions after 15 weeks. So much earlier than the viability line set forth in Casey. And so under existing precedents, this law almost certainly would be clearly unconstitutional. And the lower courts indeed did hold this law unconstitutional. But the challengers are now at the Supreme Court. The court has agreed to hear the case, which suggests that at least some justices are very interested in perhaps reassessing, reevaluating, clarifying, whatever word you want to use, at least taking a look at the existing law on abortion rights. This case will be argued this fall with a decision likely next June. It's going to be extremely politically divisive. We'll be gearing up for the midterm races for 2022, and many people will be paying close attention to this. And next slide, final slide. The final case I'll just flag very briefly is a pending request to hear a case on Harvard's affirmative action policy. The court has not yet agreed whether it will hear this case. We expect a decision on that maybe next month or potentially in the coming months after that. I think it's likely that the court will hear this case because, it is so contentious and it is such a major issue. But essentially, challengers here argue that Harvard is violating the civil rights, specifically of Asian American students, through its affirmative action policy, which provides an advantage to other people of color. Again, we don't know for sure whether the Supreme Court will even weigh in on this, but if they do, assuming they do, that will line up major cases on guns, abortion, and race, all in one term, three of the most divisive issues in public life in America. And the Supreme Court will be hearing potentially game-changing cases on all of them. So it should be interesting. And with that, I would love to take any of your questions on anything I've talked about or any other cases about the before the Supreme Court right now.
Interesting is a good word there, James. Thank you so much. I really appreciate the way you walked us through some of the big cases and helped sort of demystify what's going on at the Supreme Court. And our call to action this week for everyone is to keeping up with the Supreme Court, and following SCOTUSblog is a great way to do that. Every day, James selects a short list of news articles and commentary and noteworthy links and puts that in a daily brief kind of thing. And there are a ton of great resources there. I've already learned a lot just by exploring the site, and we'll share a link in the follow-up email later this afternoon to make it really easy to sign up for that daily digest and explore the site. James, to kick off the questions, one of the things we do at MCV and MCA is to help people figure out what's their place in our political system, in our political life. And I think how we get involved with the legislature, with the executive, those make sense. What's the role of the public when it comes to the courts and specifically to the Supreme Court?
Yeah, it's a great question. The answer is that it's very minimal. And I think that some people would say that the Supreme Court is designed to be insulated or shielded from the democratic process. Justices are appointed for life. They are not accountable to the public in the way that members of the other two branches are. Obviously, they don't run for re-election. They don't hold press conferences. They don't even allow video cameras of arguments. So it's even difficult for a member of the public to even see in person what the court is doing. There's a lot to be desired about in terms of the transparency of the court. And so I think that, that may be by design, right? The Supreme Court is supposed to be neutrally applying legal principles without considering, what a majority of Americans might desire, or what the democratic process might come up with. On the other hand, some people see the court as essentially another policy-making body that is not accountable to voters, and they see that as a problem. And they see political valence to many of the court's most controversial opinions. And I think whether justices are political actors who are unaccountable, or whether they are neutral arbiters of the Constitution and of legal principles, is in the eye of the beholder and probably varies from case to case. But it's an issue that I think about all the time. And I do wish that the court was more accountable to the public. I wish that their hearings were more open. I wish they allowed cameras in the court. I wish it was easier to find information about cases on the court. And that's part of what we try to do at SCOTUSblog. We try to make the court more accessible. We try to explain its rulings in plain English. We try to provide primary documents about the court to members of the public.
Thank you. It's a big task to wrap our heads around what's going on at the Supreme Court, but I think it would be a hopeless task without the help of really smart and excellent communicators like you. So thank you. President Biden has appointed a 36-member Supreme Court commission to analyze a whole bunch of potential court reforms and to report back to the president. I believe that's report back is due mid-November or something like that. What do you expect from the process, and what questions or issues would you put before that commission if you were in charge of the world?
Yeah, so as a journalist, as I probably just flagged, I mean, the issues that I'm most interested in, that I most care about are transparency issues. And so I would love to see that commission look at some of those issues. So for example, I mentioned the what we call the shadow docket, which is like basically a whole separate area of the court's docket involving emergency cases that come up to the court on a very time-sensitive basis. They don't get argued, they don't get fully briefed, but the court does issue opinions that can be quite important and quite significant. And many of those decisions don't come out in full-fledged opinions, they're not explained. Sometimes we don't even know which justices voted on which side of those cases. And I think that's a real problem for the court's legitimacy. And so I would love to see the commission look at proposals along those lines to increase transparency and accountability. Certainly, the commission is also going to be looking at ideas like court packing, adding seats to the court, trying to change the life tenure, term limits, lots of other things. Frankly, I don't see the commission having a great deal of impact. I think it's one of these blue ribbon study commissions that Biden is using to show that he, is thinking about the issue, but it's really just a study commission, and it's not even charged with making definitive recommendations. It's simply charged with issuing a descriptive report about various reform proposals. And so I think that if there are going to be serious reforms, they will have to come directly through Congress and probably would not come through the commission, especially because Biden has not shown this to be a top priority for him.
So those of us who were maybe hoping for some big changes to the balance of the court, this may not be the vehicle for that, huh?
I don't think that this will be the vehicle. Now, there is legislation, in Congress to make very substantial changes. There is a bill right now that would add 4 seats to the court. I don't see that bill having very good prospects of getting much traction, given the political situation, given that it would need to survive a filibuster, that kind of thing. But there are those vehicles that exist, and who knows, the political winds could change.
All right, well, thank you. We know we'll be able to count on you to keep us posted on it. One of the potential reforms that comes up, I think maybe in a less controversial way than court packing, is about the lifetime appointments. And in Maine, the Maine Supreme Court, for example, has established 7-year terms, and there's no limit to the number of terms a justice can serve, but that sort of creates a natural exit point. What are the arguments for and against term limits, and are there some other possibilities, like potentially cycling justices back to the circuit courts rather than staying on the Supreme Court for that lifetime appointment? What do you think about all that?
Yeah, so this is like a burgeoning area, and there are a lot of groups that are really trying to push these sorts of proposals. And I think something like the term limits or related proposals would be a little more politically palatable than simply packing the court and adding seats. But one major roadblock is that it's argued, like some people argue that it's unconstitutional to impose term limits. The Constitution says that justices shall serve during good behavior. And many people have interpreted that to mean that they must serve for life, meaning that the only remedy for the only way to remove a justice would be through impeachment. But there have been some creative proposals for how you could potentially allow a justice to continue to be a justice, but so not actually remove the justice from the position, but essentially impose something that would look like a term limit. And that might look like you said, Kathleen, cycling justices on and off the lower courts. The main argument, I think, in favor of term limits is that if you had a set schedule for when justices would leave the court, it would eliminate the arbitrariness of the political control of the court. If Justice Ginsburg had lived a few more months, Biden would have replaced her. And the justice that he would have appointed, I promise you, would be very different from Amy Coney Barrett. And so it's pure happenstance that that vacancy got filled by Trump and not Biden. And I think there's a strong argument that the control of the court, the control of interpreting the nation's constitution should be allocated at regular intervals so that it doesn't just come down to the happenstance of when a justice leaves or when a justice strategically leaves the court. And we're hearing some rumors about whether Stephen Breyer might do that, or when a justice happens to die.
Yeah, the political wins and personal happenstance doesn't seem like a great way to shape our court, but here we are. You mentioned good behavior, or is that what you said?
Yes, that's the term in the Constitution.
Okay. So depending on where you sit, the so-called judicial activism is either exactly what we're talking about in terms of good behavior or the furthest thing from it. And one example is qualified immunity as a judge-made law. Can you tell us a little more about that and just explain what the various perspectives are?
Sure. So qualified immunity, distinct from sovereign immunity, which is a different immunity that I talked about earlier. Qualified immunity is completely different. It is a doctrine invented by the Supreme Court, and it essentially says that lawsuits against public officials alleging constitutional rights violations often cannot go forward. The only way they can go forward is if the official or a police officer, for example, as is commonly the case, violated what's called a clearly established constitutional right. And that standard has been interpreted very narrowly so that it's almost impossible for a plaintiff to overcome that qualified immunity when suing a police officer for a constitutional violation or suing another government official for a violation. And there have been a lot of calls both on the left and the right recently for the Supreme Court to take up that issue and abolish the doctrine. Like I said, it is a doctrine sort of created by the Supreme Court, and it's caused a lot of problems. Lower courts have had a lot of trouble applying it, and it's resulted in outcomes that seem on their face unjust, because you have cases where, I don't know, I'm trying to remember like the facts of one case, like, the case, like a case where police officers will unleash a police dog on a suspect, and the suspect was kneeling on the floor and got really badly injured by the dog. And the suspect claims that it was a constitutional violation for the police officers that conduct was a constitutional violation. And courts have held that the conduct is not a clearly established violation because there wasn't directly a case on point establishing that exact sequence of facts was a violation. And so, for example, like in the case I'm thinking of, I think like there was a prior case involving police officers unleashing a dog on a suspect who was lying down rather than kneeling. And so because of that tiny factual difference, courts have said, well, it's not clearly established what the law is in this area. And so therefore the police officers couldn't have known that it was a constitutional violation. And so therefore they're immune from the lawsuit. They don't have to pay damages to the person whose rights were violated. And you have a lot of results that strike a lot of people as just clearly unjust. And so last year, there were a number of cases that the Supreme Court sat on for quite a while, asking the court to take up this issue and reconsider qualified immunity. At the end of last term, the Supreme Court declined to take all of the cases. They basically just said, we're not going to weigh in on qualified immunity right now. And so far, they have not shown any indication that they're going to weigh in on it. Although certain justices, and again, this is like an issue that sort of unites both sides of the ideological spectrum, both Clarence Thomas, who's perhaps the most conservative justice, and Sonia Sotomayor, who is the most liberal justice, have both called on the court to reevaluate this issue. But so far, not enough justices seem interested in doing so. But this is a ripe issue, and the court will probably have to confront it quite soon, I would say.
And would it be reasonable to expect that Justice Thomas and Justice Sotomayor want the court to take that up for different reasons or with different potential outcomes?
So I do think they probably have different reasons for doubting qualified immunity. I think in Thomas's case, it's basically an originalist impulse. Thomas is the court's biggest originalist. He believes in interpreting the Constitution as it was understood at the founding. And at the founding, there probably was no such thing as qualified immunity. And so he says, as an originalist, I don't think that we should, have this doctrine. And Sotomayor, definitely not an originalist, but Sotomayor is very interested in holding police officers and other government officials accountable for harming victims. And so, yes, I do think they come at the issue from quite different perspectives, but they may agree on the outcome in this case.
It's fascinating and makes me think that as a lawyer bringing cases, through the system, there must be a fair amount of, how else to say it, but political strategy about what cases you want to see brought to the court at what moment, and that feels pretty complicated to me. Is there a downside to that sort of structure where there's such a calculus about what the court considers when?
There is a ton of strategy about this sort of thing. We see it all the time in the briefs. One thing that comes to mind is that when Anthony Kennedy was on the court, he was the median justice. He was the swing vote on many divisive issues. And you would see these briefs that, coming up to the Supreme Court, and they were just kind of known as like the Anthony Kennedy brief, because they were just very clearly written with an audience of one person. And that was Anthony Kennedy. Like they would cite all of Anthony Kennedy's old opinions. They would be written in a way that was designed to appeal to Anthony Kennedy, because the litigants knew that Kennedy was likely to be the pivotal vote in those cases. And there are many other ways in which Supreme Court litigants strategize in this way. I think it's only natural that they would do so. These are very smart lawyers. They're trying to win for their clients. And so they ought to do so. But going back to what we talked about before, it does raise the impression, it creates the impression, if not the reality, that there are political calculations at stake in these cases. And many of the most divisive issues appear to be, politically oriented decision-making. Whether they are in practice or not, there is an impression that they are.
And in the preview of what's coming up in the next term, you pointed out that we've got cases about abortion and guns and race and the very most divisive and controversial issues that we face as a society. what's the danger of having those final decisions made by a branch of government that either is or at least appears to be at least as political as the other branches, and not the neutral arbiters that we've come to expect, at least in our original, our elementary school civics.
Yeah, well, the danger is that you can't vote the bums out. The danger is that if the American public doesn't like the Supreme Court's decision on abortion, they can't vote the justices out. Now, to be fair, in many instances, the political branches can overcome Supreme Court decisions. So, for example, if the court were to strike down Obamacare next month, Congress could simply fix the issue identified in the decision and pass a new law, basically pass the exact same law, just take out the individual mandate altogether, and it would solve the problem. And so, similarly, if the Supreme Court overrules Roe v. Wade, Congress could pass a law guaranteeing the right to abortion in all 50 states. There are bills to do that right now. So Congress could do that. Whether Congress would do that is to be seen. But, in other cases, the Supreme Court is the final arbiter, though, short of a constitutional amendment, because the Supreme Court, does declare what the Constitution means. And so there are situations where Congress acting alone cannot undo decisions of the Supreme Court. And, I think it's up to people to decide for themselves whether that's a good thing or a bad thing. And many people believe that we need neutral, unelected people who are shielded from the political whims as much as possible, even if they are political animals in some way. And everyone knows that they have political views of their own. But at least the argument would be that to the extent possible, the people interpreting our Constitution, interpreting our laws, should be shielded as much as possible from the political fray, I guess.
James, I am so grateful to you for sharing all of your expertise today. You said this is something that we all have to sort of figure out for ourselves. I feel much more equipped to weigh in and to figure out what I think. And I'm really looking forward to continuing to follow along with what you're reporting and analysis, and just helping to sort of crystallize some of these really complicated issues. So thank you so much for joining us today. Thanks to all of you for being with us on the day before a long Memorial Day weekend. We're really grateful for your participation and all those fabulous questions. I hope you'll mark your calendars to join us next week for a conversation with Congresswoman Shelley Pingree. Congresswoman Pingree represents Maine's 1st congressional district. She is a longtime climate and clean energy champion. We can't wait to have her with us next week to talk about ocean climate action and the state of our democracy and local benefits of the American Jobs Plan, and who knows what else, whatever you want us to talk about. Till then, thank you and have a beautiful weekend.